Transfer explained with case law. Under the Transfer of Property Act 1882, a transfer of property refers to an act by which a living person conveys property, in present or in future, to one or more other living persons, or to himself and one or more other living persons. Section 5. For a transfer to be legally valid, certain essential conditions must be fulfilled. Hab 1. Competency of transferor. Section 7. The transferor must be competent to contract and entitled to transferable property. This means the transferor must be of sound mind, not a minor, and legally entitled to transfer the property. If any of these conditions are not met, the transfer is void. Case law. Kanhaiya Lal, National Bank of India Limited, 1913. It was held that a person who is not the owner or has no authority cannot transfer valid title to another. Napak 2. Competency of transferee, Section 6 and 7. The transferee must be a living person capable of holding property. This includes individuals, companies, associations, and bodies of persons. However, there are restrictions. For instance, an alien enemy or a foreign sovereign cannot acquire property in India without government consent. Case law. Smamt Shanti Devi v. State of Haryana, 1997. The court held that the transferee must be a person competent to take and hold the property transferred to him. 3. Lawful object and consideration. The object and consideration of the transfer must be lawful as per Section 23 of the Indian Contract Act 1872. Any transfer made for an unlawful or immoral purpose is void. Example, a transfer made to defeat creditors or commit fraud is invalid. Case law. Gopal Lal v. Babu Lal, 1981. A transfer made with the intent to defeat or delay creditors was declared void. 4. Transfer of transferable property. Section 6. The property being transferred must be transferable. Section 6 lists exceptions. Certain properties cannot be transferred, such as a chance of an heir apparent succeeding to an estate, mere expectancy, right of re-entry, personal rights like maintenance, public offices or pensions. Case law. Ramaswamy v. M.L. Nagappa, 1988. It was held that a mere chance of succession is not transferable property. 5. Compliance with mode of transfer. Section 9, 54, 123, etc. Transfers must be made in the prescribed legal mode. Some transfers can be oral, if law does not require writing, while others must be in writing and registered. Sale of immovable property above 100 must be by registered instrument. Gift of immovable property must be by registered deed. Section 123. Mortgage and lease require specific formalities depending on the type. Case law. Suraj Lamp and Industries Pvt Ltd v. State of Haryana, 2012. The Supreme Court held that transfer of immovable property must be through a registered instrument. GPA sales are invalid. 6. Certainty of subject matter. The property transferred must be clearly identifiable and certain. Uncertain or undefined property cannot be transferred. Case law. Aloka Bose v. Paramatma Devi, 2009. The court held that for a valid transfer, the subject matter must be definite and ascertainable. Nas 7. Possibility of transfer taking effect. Section 1314. The transfer must be possible and not opposed to the nature of the interest. Transfers that are impossible, contingent on unlawful conditions, or perpetual are void. Case law. Stanley v. Wild, 1899. A condition restraining marriage was held void, making the transfer invalid to that extent. Conclusion. A valid transfer under the Transfer of Property Act requires competent parties, transferable property, lawful object and consideration, proper mode of execution, and certainty of subject matter.